Dear friends, the constitutional bench of the Supreme Court of India, headed by Chief Justice D.Y. Chandrachud, held that majority of the decision is that the private property of an individual or other private players could not be used for the common good by the state by acquisition of the property attached to the individuals. The point herein is that the Chief Justice of India has every right to write the judgment on his own and for other members who are concurring with the judgment of the Chief Justice of India. But he has given a different connotation to the doctrine of judgments given by Justice Iyer, Krishna Iyer. In this case, two judges, that is Justice Nagaratna and Justice Dhulia, have given their dissent voices in the majority of the decision taken by the Chief Justice of India. It is quite interesting to note down the Justice Nagaratna observation is this: merely because of the paradigm shift in the economic policies of the state to globalization, liberalization and privatization, contemporaneously called the reforms of 1991, which continue to do so till date, cannot result in branding the judges of the court of the year as doing a disservice to the constitution, Justice Nagaratna wrote. She has further said that the institution of the Supreme Court of India is greater than individual judges who are only a part of it at different stages of judiciary of this great country. Therefore, I do not concur with the observations of the Chief Justice in the proposed judgment, Justice Nagaratna categorically said. The other judge who has given a lone dissent voice, Justice Dhulia, has said rightly that the Krishna Iyer doctrine, or for that matter the G. Chennappa Reddy doctrine, is familiar to all who have anything to do with law or life. It is based on strong humanistic principles of fairness and equity. It is a doctrine which has illuminated our path in dark times. That is, Justice Dhulia said judgments like Justice Krishna Iyer were not only known for their integrity but more importantly for their empathy, or for the people as a human being was at the center of their judicial philosophy. In the words of Krishna Iyer himself, the courts too have a constituency, the nation, a manifesto, the constitution, Justice Dhulia reminded. It is of a different viewpoint that have been expressed by these two judges, contrasting the viewpoints expressed by the Chief Justice of India about the famous international fame and noted Justice V.R. Krishna Iyer. The point herein is that initially the right to property was one among the 7 fundamental rights in the Constitution of India, and it was later amended thereto in the interest of the common good, by the common good for the interest of the people as a whole. The property of individuals or individual holders holding their property for the common good could be done by the state, but the liberalization policy and the globalization policy have attracted the judiciary, Indian judiciary, to the extent that the Chief Justice of India have made a different connotation. The right to property of the individual is uppermost. than that of the interest of the people of this country. This is causing a series of concerns to the citizens of this country, those who are having faith in the socialist principles and egalitarian society in this country. Thank you so much.